This is the case number 21369-08, Lowry and Schmidt. Looks like I have Mr. Schmidt is present and Ms. Bliss is here and State of Washington is present. Are we expecting anybody else?
No, Your Honor, my client is in my conference room with me this morning. We had a little bit of a technical difficulty, so we're not on our normal camera. We're on a laptop, so I'll just have to play musical laptops this morning.
All right. So I had this is on for a trial with regards to parenting plan and child support. So I read through the trial aid, at least just kind of browse through that. I had not looked at everything in here. I guess my question is where are we with regards to, it sounds like there was at least at one point some sort of agreement. Are we not there? Mr.
I think we're back there, Judge. I did have the opportunity to speak with Mr. Schmidt a few times this week, as late as this morning, about 20 minutes ago. And from my understanding of our discussions, and I'll obviously let him speak for himself, but the sole issues that remain are my client's obviously asking for sole decision-making. He wants joint decision-making. There's an issue with regard to the tax exemption and the issue of attorney's fees. And it's my understanding that those are the sole issues before the court today. We had spoken previously about stipulating to the exhibits being admitted. I kind of explained to him what that entails. He's agreed, and again, I'll let him speak for himself, but he has agreed to stipulate to the admission of my 11 exhibits as well, given that those are the sole issues before the court today.
All right, Mr. Schmidt, I see you have your hand up. Good morning.
Oh yeah, I was just trying to figure out how to get this. I didn't understand how to do this, so I just didn't want to miss this. I was just pushing every button I could to try to get on.
Nope, you're right where you need to be. We started a couple of minutes late. I had another matter going this morning.
Okay.
So you're right where you need. We haven't started anything at this point. Were you able to hear comments Ms. Bliss just made?
Yeah, the last few, yes, I was.
Okay. So, well, it's my understanding then that the proposed paperwork that I have today, you've generally agreed with most of that. There's an issue about joint or sole decision-making, an issue about the tax exemption and how to handle that, and about attorney's fees. Is that accurate?
Yes, correct.
Okay. Everything else you're comfortable with?
Yes.
Okay. And if I understand right, it sounds like you were initially represented, I believe, by Ms. Blondin. Is that right?
Yeah, correct.
Okay. And did she work with you on a lot of this stuff? So you had a chance to get some advice on this?
Yeah, some. And then I was supposed to talk to her when I got back from work, but then that's when she told me that she can't practice anymore. So I didn't really get to talk to her about anything else that was going on.
Okay. And
And I do see the state is involved. I'm imagining it's for healthcare coverage, and I have included language that Ms. Bull, formerly known as Lowry, is to keep the child on public healthcare coverage.
right.
Your Honor, I have reviewed Ms. Bliss's proposed child support worksheets in order, and it does contain the language that the state was requesting. So I'm in agreement with that.
All right. So as far as that, are you comfortable with me putting on agreed via Zoom on these orders?
Yes.
On your behalf? Okay. And did you have any other issues that you were interested in this morning on this case?
Nope, that was all. With the court's permission, I'd like to be excused from the duration of the trial.
All right. So you are excused. I put your indication on there on the last page of the support order. And then we'll talk about the other three issues.
Thank you.
All right, thank you. Just so the child support order sounds like it is agreed then, as said, everything else fits either in the parenting plan.
With the exception of the tax exemption in section 19. Yeah.
Okay, let's talk about that first.
Okay.
Let me take a look here.
And I guess I would defer as to how Your Honor would like to proceed. Obviously, like I said, I have my client present. I'm more than comfortable putting on some brief testimony, or obviously you did have the opportunity to review my trial aid. That did contain a lot of our position as to the tax exemption as well. So I'll defer to the court as to how you want to proceed with that.
Okay. I guess, well, let me just, I mean, I did look through those. I guess my question is what is the position that you've each got on there and the reason for that? That's probably all I really need to know. I don't know that I need testimony.
Okay.
I just know argument as to what that position is.
Absolutely. It's my client's request today that Your Honor award her the tax exemption every year. If Your Honor had the opportunity to review the trial aid and the proposed orders, my client does have the child the majority of the time. Mr. Schmidt's time previously was about 48 hours twice a month. Just whenever he decided to tell my client that he wanted to exercise time consistent with what he has indicated previously is a difficult work schedule, that resulted oftentimes with minimal visits, if any visits. Now under the current parenting plan, we are asking for an every other weekend type schedule, which he has now agreed to. So the hope is that he will be more consistent. My client's position is that she should be awarded the tax exemption every year. However, she has agreed to every other year, so long as he is consistent with visitation and consistent with his child support arrears.
All right. And Mr. Schmidt, what is your position on that?
Yeah, if I could say, a lot of the times that I tried to pick my son up, his mom would not let me, because of the girl that I'm seeing. So she is saying that I was not wanting to do it, and I was trying to be more consistent and trying to get him more. But with her, it was I needed to get rid of my girlfriend if I wanted to see him more. So that's the reason it was inconsistent on that part of her saying that I wasn't watching him that often, because I was trying to, before me and this girl that I'm with now got together, I had my son all the time. Like I'd get off work. I mean, I'd come home from work and I'd call her and pick him up that day, and I'd have him for 3 or 4 days and then give him back. And I was doing that consistently until me and this girl got together, and she said she didn't want my son anywhere near him. So every time I would say, hey, I'm home, can I get him this weekend? Her response would be, is your girlfriend going to be there? And I'm like, well, yeah, she's going to be here. Well, then you can't see him. Like, she needs to not be around if my son's going to be around you. So that's why it was inconsistent. And I think if I'm caught up on my child support, and I'm always paying child support, and my son's on my medical and everything. So I want to, because the last 4 years she's claimed him. So I want the next 4 years, and then after that, we can rotate, or even 3 years. If I claim the next 3 years, then we can alternate. I don't mind alternating, but it's just the last 4 years she's claimed him.
Okay. All right. Excuse me.
And can I add something again? I'm sorry, I didn't mean to interrupt you.
Oh, no, sure. Go ahead. This is just on
and-
for the tax exemption.
And as of like her saying that I never paid anything, I was paying her child support. I was giving her, we agreed on a certain amount, but every time I went to pay her, she wanted more. And then I would give her a little bit more. And then the next time I'd go give her some more money, she'd call me and tell me that she needs more money the next time. So it was never a consistent, like what we agreed on. And then I was still doing it. And then she'd tell me he needs school clothes. Okay, so I went and bought him school clothes, dropped them off with her. And then she would call me again and say, well, now we need groceries. So, okay, well, I mean, and then she's like, her electricity bill is due, or her car payment is due. So it was constantly like, I need to pay more and more and more every single time. But I was paying her money. I mean, I was giving her money, and I was paying for extra like school programs, or if she needed school supplies or something. I was trying to help her pay that, but it was constantly, I need more money. I need my rent's due and all this stuff. So that's why it didn't work out with that.
Was there a prior order of child support?
No, this was something me and her agreed on when we first split up. That I said, he's my son, and if you need help, I will help you, and I will give you some money. This was something me and her just came up together. But then all this changed as soon as me and this girl got together. Everything changed.
Okay.
Yeah,
Like,
there's the temporary.
I wish I would have. What?
But let me
Sorry.
with Ms. Bliss for a second.
I was going to say, Your Honor, there was a temporary order of child support entered in this matter back, and I don't have the pleadings in front of me. I was trying to pull it up on Odyssey real quick, but I want to say
July of 21, it looks like.
sounds about right.
Yeah. And so I guess my question prior to that, what was happening? I mean, it sounds like you spent some money, but what
prior to your to the court's order?
Mhm.
Is that what you're saying?
Yes.
That's what it was. I was picking my son up when I was in town, and then when she needed money, I would send money. If I was out of town and she'd call me, I would send money to my nephew, and my nephew would give her the money because she'd say, I need groceries, or like his clothes, he needs new clothes, or when school started, he needs school supplies. I always paid for the school supplies. I paid for his clothes and stuff like that. And then, like I said, it got to where she was like, my car payment's due. And as I told her, it's not my responsibility to pay car payment. And her status was, well, Mason has to be driven places. He has to live under a house, so you have to pay all these things. And I felt like I was giving her like $350, $400, and then she'd ask for more.
Okay.
But then, like I said, once I got with the girl I'm with right now, like everything changed. She told me that I either get rid of her and don't be with her anymore, or she's gonna destroy my life. And that's when everything started going bad, and then she took me to court. But I was trying to be as consistent as I could with my son and picking him up as much as I could. And it wasn't this 48-hour notice thing. So I got to spend more time with him, because sometimes I'm only home for 3 or 4 days. So now I would keep him those 3 or 4 days, but now I have to give 48-hour notice. Then I only get him for 2 days if I go back out of town.
Okay. All right. Well, my normal ruling, which in this case seems like it sort of fits within these parameters on that issue alone, it looks like at least you're imputed or at similar incomes. Currently, there's not a lot of impact on the exemption in the federal tax law. However, there are some things that come out of that. Generally, what I do on these is I alternate back and forth. And I don't necessarily, I mean, I look back, but that's not the deciding factor. It would seem to me that if she's been claiming up to now that for this year, which would be 23, so each odd year starting this year, has everybody done their taxes for this year, I assume?
My client hasn't completed her taxes yet. No, she wanted to wait until today's outcome.
Okay. And to your knowledge, is he current on his support for 2022 or 2022?
Yes, Your Honor, he is current.
Okay. Well, why don't we do this? I guess I'm inclined to alternate, and I'll do it in even years starting for 22. So Mr. Schmidt, you would claim the child on your taxes for this year, the ones that you're just about to file if you haven't done that. You may need to end if you already have. I don't know if there's going to be any great impact on your taxes because the tax laws are kind of strange right now, but I'll grant that to you each even numbered year. So when you file in an odd year, you're filing for the even year.
Okay.
Filing your 2022 taxes, you would get to claim him. That is so long as you're current in your support by the end of January for the year. And I do, because if you're paying through support enforcement, sometimes it takes a few weeks for that credit to show up on them so that we have evidence of that. So I think what I'm going to ask Ms. Bliss, I'm going to ask you, because this is really tight in here and I don't want to scribble this up too badly, would you be able to submit an updated child support order that includes that language?
I can, yes.
Okay, and that doesn't need, if nothing else changes, that can just simply indicate that Ms. Powers agreed electronic or via Zoom.
Okay.
And that with that change, then I'll sign that order when I see that.
Very good.
Okay, and I have signed the worksheet that is appropriate already, so I've signed that.
I can send that over today.
Great. Okay, so let's talk about the other matters, which is the decision-making and fees. Let's talk about decision-making first.
And are you wanting just argument on that as well, or would you like some testimony from my client? I think it's pretty basic. I mean,
Yeah,
what
I
I
think
have her testify.
Yeah, I think I read through your declaration or your trial age. So I think probably I can just hear your argument. I can hear from Mr. Schmidt and probably make a decision.
Very good. So, Your Honor, we do have an 11-year-old child, Mason. Throughout Mason's life, my client has been the primary parent of Mason, has made the doctor's appointments, the dentist appointments, has made the decisions with regard to vaccines, with regard to any sort of necessary medical treatments, braces, and the like. My client is simply asking to just continue that moving forward. She's not asking to essentially exclude Mr. Schmidt. She's just asking the court to not order that she consult him prior to making those decisions. Given that the history between the parties, the findings that are included in the parenting plan, I do believe that it's appropriate at this time that she have sole decision making, and so that's what we're requesting at this time.
Thank you. I apologize. I got a bit of a throat thing going here this morning. Mr. Schmidt, what's your thought on the decision-making issue?
I want it to be both of us, we consult each other, and that is not accurate what she's saying. I took my son to a lot of appointments, doctor's appointments, dentist appointments. I took him to a lot of them. Some of them I was out of town, and I'd call her right away and be like, hey, what happened? What was the outcome? And so it's not like I wasn't concerned, but I took him to a lot of appointments because before I used to be a part-time employee. So I was out of town for a little bit, and then I was home for 3 or 4 weeks. And then sometimes when she was at work, she'd be like, I can't make appointments on these days. Can you take him these days? And I'm like, yeah, I'm home, so I'll be able to take him. So it wasn't just her every single time. Sometimes when I was out of town, yeah, she did have to take him to appointments, but it wasn't just her. I tried to participate in, and sometimes I even took time off work, and I was like, we both need to be at this appointment and for my son, so I'm not going to be able to make it to work. So I just feel like on that we should both. And then when my son got hurt not too long ago, I called her and let her know he was with me. I don't feel like I had to tell her, but the fact that he's both of our son, like I feel like she needs to know that what happened to him. I don't feel like it should have just been like, oh, you'll find out when you find out. So I called her immediately and said, meet me at the hospital. That he's going to the hospital. So I feel like we both should be included in that.
Okay. These are kind of difficult ones, and part of the problem in this is there are some factors that I'm not able to not take into account, which has to do with there is some prior history between you two, which places some legal limits that I need to follow. And that has to do with and I know these are old, and it sounds like you two have moved past a lot of these things, which is good to hear. But the old protection orders and things, those impact what I'm able to do. I think I think I'm compelled under state law to leave it sole on the school and educational and on the healthcare non-emergency. That means that if child's with either of you and something happens, you got to take them to the hospital, you take them to the hospital. You don't need to get the other parent's permission to do that. What I don't see in here, which I would like to see, would be some language indicating that each party would advise the other party of any emergency healthcare, health treatment or that sort of thing as soon as feasible, which is quickly. It may not be immediate, but as soon as feasible. And I think that goes both ways, because obviously you both need to know that. The other piece I think I'd like to add in there would be that if there is a decision being made that requires a financial impact, that would be something they should consult on. So that's kind of the limits of what I can do, sir. And I think those are those are things that impact you directly. So if that would be things like braces. The braces typically cost a whole bunch of money, and that you would have input into that decision.
So
the paper part.
So I wouldn't have any input on vaccines or any of that kind of stuff because I really am like, I don't believe in any of those.
On the basic healthcare stuff, that I am pretty much required under state law to leave that with the custodial parent when there's a case where there's a history of domestic violence. And again, it sounds like you two have moved past that, and that's good to hear. But there are limits that roll from that I'm not able to really overcome. So what I'm doing is I'm trying to give you updates as quickly as possible on any kind of critical procedure. And then anything that impacts you financially would be, you'd have input on that.
Okay.
So, Your Honor, if you'd like, I can submit the parenting plan and maybe just put some asterisks underneath that section 5. Okay, I can do that.
I think it'd be cleaner if we did that.
Absolutely.
Leave everything else the same there. Then the other issue is fees. I think the request, if I read it right, was it 5,000?
That's correct.
Any comments on that if you'd like to make?
And Your Honor, I think that my trial aid speaks largely for itself, but as Your Honor is aware, at least from the court record, this matter was set to go back in the fall. Ms. Blondin was counsel for Mr. Schmidt at that point. We had reached an agreement, struck the trial pursuant to that agreement, had several court hearings thereafter, simply trying to present those final orders. Unfortunately, as the court is aware, Ms. Blondin is no longer allowed to practice law, so those orders were never entered. Even after that, I still attempted with Mr. Schmidt to submit those orders. He simply stated he did not agree. I understand he's without counsel and he doesn't know as much as, obviously those of us who practice. However, we're before the court today on the exact same issues that we had at the last trial. Ms. Blondin and I had resolved the entirety of all of the other issues, with the exception of the decision-making, the attorney's fees and the tax exemption. So my client has expelled significant attorney's fees from the point of the last trial being prepared to go, striking it on the eve of trial, and then being back before the court today on very minimal issues. He does make, the parties do make similar incomes. I do recognize that. However, he's been without an attorney for over 4 months now, while my client has expelled significant attorney's fees just trying to get this case wrapped up.
And Mr. Schmidt, your position on that?
I feel like I was paying for my lawyer. I didn't ask her to pay for anything. And I was also accruing lawyer fees and I was paying child support. I was current with everything. So I feel like if like the debt that I incur is for me to take care of. And I feel like hers is for her to take care of. And she's got a husband, her and her husband both work. I pay for everything here by myself. And I just, like I said, I feel like that's like, how can I pay for her to sue me? I don't understand how that's like how that is, because like even if I had $10,000 or this kept going and I had $15,000, I would be responsible for my $15,000 or however much I incur. I would never ask for her to pay my bills just because we're not agreeing. And I've agreed with a lot of the stuff she's wanted. And I'm said, that's fine. I'll do that. I'll put him on my insurance. I'll do whatever else you're asking. And it's like everything I asked for is a no. Like, I'm not doing that. This is not going to happen. It's just the only things I'm getting put on me is I'm paying for everything. But if I make a decision on something like, hey, I would like to be able to be more a part of this, it's a no. But it's like, well, he's paying for this. Okay, yeah, that's fine. He can pay for this or he can pay for that. But when it comes to anything else, she didn't want to budge, or we would have had this done a long time ago. It's just like it's just a take and no give. If that on my position, that's how I feel about it.
Okay, thank you, sir. So just, if I understand correctly, this was set for trial and then it was stricken because of Ms. Blondin's situation?
No, Your Honor, the parties had reached, at least from my discussions with Ms. Blondin, we'd reached an agreement. So we'd struck final because we were going to do final orders.
Understood.
And can I say something about that?
Sure.
Yeah, I never agreed to anything with her. I told her when Andrew was my lawyer, I was in Seattle and I talked to her and she said, I need you to be here as soon as possible. And then I left Seattle because that was my last day of work. And then I called her and tried to set up a meeting. And then she told me she can't practice anymore. And then she said she needed me to sign these final things. And I was like, I never agreed to any of this. And she said, unfortunately, I can't help you anymore because I can't practice. but I need you to sign these paperwork. And I said, I never agreed to any of this. And me and you were supposed to have a meeting about this.
Okay. All right. Well, and I will make an assumption that you paid Ms. Blondin some amount of money, obviously, for her representation up until she was not doing that.
Yes, I did.
Well, simply looking at the incomes here, you folks have similar incomes. You both have actually, fortunately, better incomes than most of the folks that we tend to see in court. Unfortunately, that doesn't mean you have a lot of money. It just means you're better off than most of the folks that I see come in here. Both of you are. These cases, unfortunately, end up costing just a lot of money.
And can I just add one more time that I'm doing this by myself.
Mhm.
I don't have, and she has her sister living with her that's helping her pay. She's got 3 people that are helping pay. I'm doing all this by myself, and I sometimes I get the small, like really small checks, and I can barely pay anything. So it's just, all it's gonna do is make it so I have to try to work more, and then that's gonna be less time with me and my son just to try to keep up and survive.
Mhm.
Like I'm already, I paid Andrew a lot of money. I'm still actually paying that off to my work because I borrowed all that money from my work. And so I'm paying all that off. I'm just trying to pay all this debt off so I can have some money to survive.
All right. Were there any temporary fees entered in this case? I didn't notice.
I do believe that Judge Scudder entered some fees at the last presentation hearing when we attempted to enter those final orders that we had reached an agreement, or I thought we had reached an agreement on, and I believe that was $500.
Yeah, it was $500. And I paid that right away because I know I missed the court date and everything, but like.
All right. Well, I think what I'm going to do in this case, there is a difference in incomes. It's not as significant as I typically see. Obviously some of this has to do with the fact I assume that Ms. Blondin was out of the case, which is not his fault, obviously. But there is still a difference of income, and had we come to this point after a trial, I would still likely order some fees. This is based on state law, sir. This has nothing to do with anything else. It's just we look at people's incomes, we make a decision based on, and if the situation were reversed, I'd be doing the same thing the other direction. So it's not anything other than that. I'm going to order $2,500 at this point, and that would be under the same terms that you've got in there. It is payable in 90 days, so you'll need to work. And you may contact. Is he paying this for your office?
Yes, you can pay it through my office, and then if there's any funds that need to go to Ms. Bull, I can arrange that.
All right. So, and if you contact her, if you can't pay that all in 90 days, if you contact her and you're making good efforts, you probably can work out something. But in the meantime, I will order $2,500 in that.
So with those changes, Your Honor, I'll submit new final orders, parenting plan, and child support order with those changes.
Okay.
And I can do those today.
If you want to, I think these are all, if you can get those over today, we'll get them signed and entered. And like I said, I've already signed the child support order. I'll give that to Brooke right now.
So, hey, excuse me, I have a question.
Yes,
so
sir.
the fact that I'm doing this by myself and they have 3 people paying, I still have to pay her. You can't put into account her husband's income and all that stuff. I don't understand.
Well, I'm looking at what the state law tells me to do. I'm looking at 2 parties and your incomes that I'm dealing with regards to this case.
Okay.
Okay. And sir, it sounds like you two have worked through a lot of the issues that you had years ago, and I'm glad to hear that, because your interaction with your children or your child is really important to your child. It's important to you, but it's much more important to your child in the long term. So I really urge you to work your schedule so that you can maximize the time you got under this schedule, because again, that's in your kid's best interest.
Yeah, if I might say something, it's not me. It's the fact that I have a different girlfriend and his mom will not let me see him.
Okay. Well,
that's just how it is. That's how it's been since me and her been together. If she's around, my son cannot be around.
Well, I didn't,
And that's how I feel. I feel like it should be
Yeah.
in the best
Hold on.
interest of the child. I'm not worried about her husband.
hold
Go
on
ahead.
a second, hold on a second, sir. Ms. Bliss, I didn't see any restrictions in the parenting plan as far as that.
There are none.
I'm sorry, there aren't.
There are none.
All right, so, and now I'll give my lecture on these things is that, absent there being a very good reason for not being in contact with another party, like girlfriend or boyfriend, then visitation needs to happen, assuming it's scheduled. So those get people into contempt all the time. So I would urge both of you to follow the plan. That's why it's there. And again, sir, hopefully what we're going to do is we're going to move forward from here, and you two are going to be able to work together, follow the plan, exercise as much of the time as you can. It's in your kids' best interest. And hopefully I won't see you back here. It's our goal. Okay.
Yeah.
All right. I'll await some paperwork and then we'll get this taken care of.
Very good. Thank you, Judge.
Your Honor, this is the clerk.
Yes.
I don't know, I apologize if I missed it, but I don't know that we've actually admitted Mrs. Bliss's exhibits. Are we admitting those or withdrawing them?
I'll admit those by stipulation for all of the exhibits, which I think there were 11 exhibits.
Correct.
And that was by stipulation. Sorry about that.
Thank you.
Got to keep our record clean. And I assume everybody's agreeable to destroy any exhibits.
That is correct. I would just ask that if they were submitted with a binder, that those be put back in my box.
We'll stick it back in your box.
Very good. Thank you, Judge.
All right. Thank you. And then for my clerk, I'll sign the order on the exhibits when I see you.
Thank you.
All right. Y'all have a great weekend.